All right, we'll now take up State of Florida versus Times number 2024-0647.
Mr. Chief Justice, and may it please the court, Derek Monson on behalf of the state. 3 sources of law require the police to knock and announce their presence when serving a search warrant: the U.S. Constitution, the Florida Constitution, and the Florida statutes. It is well established that the drastic remedy of suppression does not apply to the constitutional violations, but under this court's precedent, it does apply to the statutory violation. Of course, the legislature could provide for that somewhat counterintuitive result if it wanted to, but there is nothing in the knock and announce statutes that purports to require the remedy of suppression, and this court should.
In fact, it provides a different remedy, right?
Correct, Your Honor. Specifically, the search warrant knock and announce statute provides for criminal penalties if for police that engage in willful or unnecessarily excessive violations.
Out of curiosity, does the state prosecute those, or has the state sort of not made the decision to prosecute those and to ignore that statute and to instead rely on the exclusionary rule as the remedy?
I'm not aware of any prosecution that the state has undertaken. That may very well be because this court has provided for a different remedy, which I think is just another reason that the court should recede from those cases adopting that remedy, because when the legislature creates a remedy of its own, that is the remedy that the legislature wanted to impose for that.
Let me ask you about something related, and that is the knock and announce rule in the context of arrests. Is there a legislative remedy for that that's analogous to the one for the knock and announce violations, assuming that, I understand counsel thinks it's not really, the opposing counsel thinks it's not really a remedy for that, but there's something analogous to the search warrant context?
It's not that I know of, Your Honor. I don't
You
think
probably would know of it.
That's right. So I don't think there's a comparable statute in that chapter to Section 933.17.
So that might affect the way we analyze this. I mean, possibly. Wouldn't you agree? I mean, to the extent that we rely on that, if we rely solely to reach your position on that, the existence of that statute, that might dictate a different result in the context of arrest, potentially.
Yes, I do think that's right, Your Honor, if you did rely solely on the provision of a different remedy in the statute, although we don't think that that's actually necessary to the test, because what this court has said, I mean, the question of whether the exclusionary rule applies to a statutory violation is simply a question of statutory interpretation. And what this court said in Jenkins and in Lukehart is that if the statute does not expressly provide for the remedy of suppression, then the court should not read that remedy into the statute.
So should we, and I think this is where I think it's an interesting issue, though, because do we sort of put ourselves back in the shoes of Justice Terrell from 1960, whatever, and decide were they right about the court's authority to kind of imply this remedy? Do we how are we evaluating that decision? Because they obviously weren't sort of purporting to kind of interpret the words of the statute. It seemed like it was a combination of the statute and then plus whatever they understood sort of the judicial role to be there to kind of figure out what to do if there's a violation. And then, 60 years later or whatever, we're going to come along and say what? Are we going to say that your interpretation of the statute was clearly erroneous? Are we saying that it's not really a statutory interpretation question, but are kind of the way, the judiciary sort of created this remedy and so we can take it away? and kind of punt it back to the legislature? I mean, how would we be explaining ourselves to change the status quo that has been in place for 60 years or whatever?
So I think that you could say either. So the question, again, when we're talking about a statutory violation, is a question of statutory interpretation. And regardless of whether you think the court in Benefield misinterpreted the statute or misinterpreted its role as a court and didn't even purport to be interpreting the statute, I think either way, you could say that it was clearly erroneous for them to even go down that track. The only other thing I would note, in addition to the statutory text, is the historical context surrounding the adoption of this knock and announce statute. So
going back to Benefield, how much of it do you think was purely constrained to a remedy for a violation of statute, and how much of it do you think was more of a holistic, was the search reasonable, without really saying they were doing a constitutional analysis, but going back and citing to whether or not a search itself was reasonable versus in the context of not having a warrant versus a knock and announce statutory violation in the context of a warrant?
I think that's a fair point, Your Honor, and that is something we raised in the brief. So I think Benefield is a little unclear on whether it's addressing a statutory violation or whether it thinks the statutory violation rendered the search unreasonable for purposes of the Fourth Amendment. And it's plausible to read it as a Fourth Amendment case that they were applying the Fourth Amendment exclusionary rule, which would have been abrogated then by the U.S. Supreme Court's decision in Hudson.
So if we receded, and it's also, it pre-exists the conformity clause and all sorts of other things. So if we were to look at this as whether or not we're receding from cable, do you think we need to explicitly recede from Benefield given how different the analysis is?
I don't think you need to. You can certainly read Benefield as a Fourth Amendment decision, and then you could say that cable was clearly erroneous in interpreting it as a question of statutory interpretation, and then also then the statutory analysis that cable purported to do, which I don't know if there was much of any, because it just invokes stare decisis, that was clearly erroneous, and you could then recede from cable. We think that would be a perfectly reasonable way to do this. In the last point on this, the exclusionary rule, the knock and announce rule, is a common law rule that has existed for centuries. The exclusionary rule was not ever understood at common law to be a remedy for a knock and announce violation. In fact, the common law had no exclusionary rule at all. Normally, when a statute codifies a common law rule, we presume that it brings the common law soil with it, which would include any mechanisms of enforcement. And the fact that this statute was adopted in 1923 before this court had ever even adopted an exclusionary rule for Fourth Amendment violations, and the exclusionary rule in federal court was a relatively recent invention at that time as well that had not been incorporated against the states. There's just no evidence to support the notion that the legislature was withdrawing from decades of common law practice when it codified this common law rule. And so then the only consideration left under this court's stare decisis test, as announced in Poole, is whether there are sufficient reliance interests that warrant standing by the clearly erroneous precedent. And this is precisely the sort of evidentiary rule that this court has said usually does not have any reliance interest. People don't ordinarily order their affairs around evidentiary rules. When Mr. Times here committed his crimes, he had no idea whether the police were going to comply with the knock and announce statute. And even if he did, I'm not sure a reliance in committing crimes is a sort of reliance interest that this court would ordinarily protect with a stare decisis test. If your honors have no further questions, I will leave any remaining remarks for rebuttal. Thank you.
Thanks.
Good morning. May it please the court. My name is Kevin Alvarez. I'm here on behalf of Keith Times. I think the time frame is important to get right because I think it's important to the analysis of the statute and the remedies. I would fully concede that if this was a newly enacted statute, I lose because it doesn't list a remedy in the statute. But I don't think that we should analyze remedies of statutes that were enacted in 1923 through 2025 lenses and vision. And so what we have first in 1914 is when the federal government applies the the federal courts apply the exclusionary rule, the federal exclusionary rule. And then we have the decision in Atz versus Andrews, at least in the opinion that provided relief, understanding, and I apologize, reading older cases is sometimes difficult. I think it may have been more of a plurality opinion than a majority opinion.
Well, it was a two-person opinion.
A two-person opinion with then some issues on certiorari jurisdiction.
If I understand, I mean, you agree that the opinion that you're relying on was joined by the author of the opinion and one other justice.
Yes, sir, but it's not the only opinion that I'm relying on. But yes, that it only has the.
Well, I'm talking about Apps.
Yes, sir. And Apps is the opinion of the Chief Justice joined by another justice, and the
well,
Chief.
And what that amounts to is not that different from an ink blot.
Yes, sir. Except I would note, though, that what you have is this discussion that's taking place. And
there's a lot of discussions in the world that don't constitute judicial authority.
And I recognize that. And so we have in 1922, we have Atz, we have the writings that had there been the introduction of illegally acquired evidence, it would have been reversible error, and the forcefulness in which the Chief Justice wrote his opinion. It seemed like that would be an accepted practice.
I've read a lot of forceful minority opinions that might bear fruit years down the road, but they as authority, it means nothing. The forcefulness of it means nothing.
And I recognize that, but then we look at 1924, where we have the Jackson decision talking about the requirement of strict reliance in the search warrant statute. We then have Hart in 1925 applying the exclusionary rule to a violation of Chapter 933. And then we have in 1946 Johnson, which I agree didn't grant relief in the knock and announce context, but it discussed and reviewed a motion to suppress and the lower court's denial of a motion to suppress on a knock and announce violation. And while it held that suppression wouldn't be granted in that particular case because the court had made factual findings determined that there hadn't been a violation of the statute, the court didn't say, well, we don't review knock and announce violations as not having a remedy.
We're considering this from a methodological standpoint, though. Why would we focus on a string of federal opinions, some precedential authority, some not, when we have a common law background that Florida statute says is what our statutes are based on that don't apply this exclusionary rule? Why do we ignore that in favor of this kind of limited line of federal precedent?
So the cases that I was citing are Florida Supreme Court cases, so they were a line of Florida cases, and I think that it's fair to assume that the legislature, when it enacts a statute, is aware of what the law is that this court has issued at the time that they're enacting a statute. And so I think it's fair to assume that the legislature had read those opinions, and in 1923, all they had was the benefit of arts. And I understand that if it was a majority opinion, I'd be in a much better position than if it was just that.
But, counsel, I mean, the idea that you're relying on that, I mean, that's, with all due respect, not a serious argument. That's authority, and that is anything other than somebody expressing an opinion. That's just not authoritative. There's no view of the way courts make authoritative decisions that would identify that as any sort of authority. I mean, don't you agree?
And I recognize that from 1922. I absolutely agree and understand and agree with that, but then we have to deal with Hart in 25, dealing with a violation of statute of 933 2 years later. And so the point that I was making is that this idea that illegally obtained evidence should not be admissible in Florida courts was not some sort of new idea at the time that the statute was enacted. It at least got some writings from this court prior to the enaction of statute and then was applied by this court after the enaction of the statute. And the arrest component of this statute was added, because we have the knock and announce for search warrants and knock and announce for arrest warrants, was in 1939, which was after the application of the exclusionary rule in Hart in 1925. And so I think that's why the time frame is important. And so what we have to assume, because this court's not writing on a blank slate when it makes a determination in this case, you have to assume that
So you're referring to a case called Hart?
Yes, sir.
Well, is that cited in your initial brief?
No, sir. It's cited by the state in their initial brief. The case is...
And you don't address it in your brief?
I do not. It's 103 Southern 633, and it's cited on page 21 and 22 of the brief of the state.
Okay, thank you.
Yes, sir. And so the exclusionary rule wasn't applied to the federal exclusionary rule was not made applicable to the states until Mapp versus Ohio in 1901. And so these cases that apply exclusion to statutory violations predate Mapp. And since this court's not writing on a blank slate, I think the court needs to, the court would have to find that predecessor courts had clearly erred in analyzing that exclusion would be the expected remedy for a violation of Chapter 933.
If that's the expected remedy, first of all, it's not in there, so
Yes,
we're saying it's expected. Why would they provide other remedies?
Your Honor, I think on a new statute, I agree with the court 100% that if this was a newer age statute and they had provided another remedy, that would then exclude other remedies. And I think the legislature would know when they enact a statute that that's the position that the court takes today. And if they want effect to be given to their statute, then they need to apply a remedy to it in the actual text of the statute. I'm suggesting that's not the understanding that the legislature had in 1923 when they wrote this statute.
How would they have had a different understanding in 1923?
And
It's not in the common law, right? The exclusionary rule is not in the common law.
I don't want to concede that issue because I was of that same opinion too when I initially was doing my briefing that there was no evidence of it to support. In prepping for our argument, I've done more research, and I'm not actually sure that there was no evidence of the exclusionary rule being applied.
We don't have any in the briefing.
That's correct.
Okay.
I think what you're saying is that the legislature would have had a different understanding of judicial power in 1923 versus now.
Yes, Your Honor. The rules of engagement were different then, and so when they wrote a statute, they assumed that the court would provide some effect to the statute.
I guess I understand what you're saying. So you're saying because there's cases doing it, the legislature would have essentially conceded that that's what judicial power meant at the time.
Yes, Your Honor. They would know that if they wrote a statute and that statute wasn't complied with, that there would be the judicial remedy applied and I understand that the argument's a little weak that in 1922 with arts that would have put the legislature on notice, but we're looking at a different time period.
Don't you have another sort of pretty serious historical problem with the fact that the exclusionary rule, as developed and articulated in the line of cases that we've been walking through, is about addressing unreasonable searches and seizures. Here we have a warrant. So by definition, this is a reasonable search and seizure. The problem is with the knock and announce rule. It seems to me like the part of the error, if there was an error, in this court's jurisprudence and perhaps in your argument, is not to recognize that the exclusionary rule, as developed in the United States, is a rule about dealing with unreasonable searches and seizures in some cases, in absence of probable cause, in other cases, in the Miranda context, in an abuse of an individual's, Fifth Amendment or Fifth Amendment rights, more precisely. But nowhere do we have an articulation of how the exclusionary rule relates to the manner in which a search warrant, which on its face is both evidence of probable cause and of a reasonable search, is executed.
I understand and I think I argue in the briefs that on a Fourth Amendment standpoint, as it's currently understood, I lose. This is all about statutory remedies, and the Fourth Amendment has no bearing on that. And the question is, can the legislature apply or provide additional level of protections for Floridians? States are different.
But they didn't, right? They didn't provide that. There is no remedy in the statute.
I think if that presupposes that when the legislature passed the statute, they would not expect the exclusionary rule to
But
be
they
applied.
wouldn't. There was nothing to say they would have at 1923,
In the text, Your Honor,
or
is
in
correct.
history, or in common law, or in any case.
Only the commentary from 1922.
So we're going to assume the legislature
then-
may or may not have read that, but I don't think they would vote based on a two-person concurrence.
Maybe not, but then shortly thereafter, with justices that were around at the time in 1925, they applied the exclusionary rule to a violation of Chapter 933. This is the difficult thing in these older cases. I certainly wasn't alive back then. I don't know what the conversations that were going on in the halls of the legislature would. And legislative history, I tried. I went down to the archives and dug through.
Well,
and
even if you'd
there
found
wasn't
it,
much
the
there.
conversations that were had in the halls of the legislature probably would not be very persuasive to this court.
Certainly not with today's analysis, but the fundamental question is, what did the legislature intend at the time that they passed the statute? And nowadays we look to the text of the statute, and that's the lodestar for what that's how we determine what legislative intent was. Primarily is what's the text. I'm suggesting that may not have been the analysis that would have been done.
Is there any authority, if you look back at cases from 1911 or some from 1898, is there anything to suggest that this court back then considered the text indeterminate of what a statute meant? In other words,
prior to the enaction of the statute?
Yeah. I mean, I'm struggling. What you're arguing is it's kind of a big deal. In other words, that we look at every statute that predates a specific point in time. I'm not sure when your point in time is, but not for what the text means and not what it meant at the time, but for what the legislature would have assumed would have been the case. That's a completely different way than we've ever looked at statutes before. So I'm wondering what in our case law from that time period makes you think that was the methodology. And then if there's something supporting that, when it stops.
I would suggest that once the court in 1925, 1946 is clearly applying the exclusionary rule to those statutes, and we also have legislative inaction. And I know that's not necessarily, the court always considers that to be the strongest argument, but what we have is we have an opinion from this court, Cable, in 2010 in dissent specifically telling the legislature, you can change the statute if you like to, and there's deafening silence from the legislature on that. Not that I could find a single bill introduced.
Would you believe me if I told you that the legislature might not actually hear and pay attention to every pronouncement we make?
I wouldn't disagree, but we do have 67 elected sheriffs in the county that I do think have some interest in the exclusionary rule being applied.
Well, they
to
may
search
very
warrants.
well have other fish to fry, bigger fish to fry.
But I mean, just on the methodological point, though, it's not just a matter of the words in the text. I mean, I think everyone throughout any kind of period of interpretation would agree that when a statute comes into effect, it sort of drops into a sort of surrounding body of law. And it sounds like the problem isn't so much just the idea, just conceptually, that you would look to the surrounding body of law in addition to the text to understand sort of what the quote-unquote law, applicable law is, which could be a mix of sort of the background tradition and the text. But it sounds like the sea into which this law dropped did not include an exclusionary rule. I mean, it sounds like that's the problem for you.
The text does not, and
well, the text doesn't. Nor did the background into which it was placed include the exclusionary rule. I mean, that seems like that's the hurdle. That's the problem that you have.
I understand that that's definitely the problem that I have. It's not a fatal problem by any stretch of the imagination, I believe, because you have cases from that time shortly after the enaction of the statute explicitly applying the exclusionary rule for statutory violations of 933.
Well, maybe they were wrong.
But and that is always a possibility that a predecessor court has erred. But we're talking about a number of different decisions. It's just not Cable. It just wouldn't be Benefield. You'd be looking at every time the exclusionary rule is applied to any violation of 933.
Why do we have to make it that broad? Because really the issue is Cable. Not every time the exclusionary rule has been applied. And so if we craft this opinion from the context of a violation of statutory violation in the context of a warrantless search versus, the Benefield scenario where it's not reasonable at all, it's not a reasonable search at all, why why are we kind of affecting this whole line of exclusionary rule cases versus answering the narrow issue, which is whether a statutory violation of knock and announce requires this remedy?
I don't know how you can do it otherwise. Either you find that because the text of Chapter 933 doesn't provide for an exclusionary rule, I don't know how you could craft an opinion without then finding that every violation of 933 that's not a constitutional violation that the exclusionary rule can't apply to. I think logically it would have to go and wipe out the exclusionary rule.
Yeah, and I'm not so much talking about violations of 933. I'm talking about, like, for example, Benefield.
Yes.
Would you agree that Benefield seems to be going beyond a pure statutory analysis?
I think it can be read both ways, yes. I don't think my friend on the other side is wrong on that. I think you can read it both ways.
Surprised to hear you say that.
Well, and
I mean, it's like the thing says it's a violation of X statute, and therefore the remedy is that. I mean, I know that there was a lot of interesting stuff that preceded that, but.
It does. I don't want to make my friend's argument necessarily for them. I do recognize it started going into the unreasonableness language that reeks of Fourth Amendment analysis, but I do believe that Benfield was addressing it on the statutory issue. I just am agreeing that it can be read either way. But I certainly don't think cable can be read another way, and I think the court still would have to agree with my friend to get around Johnson in 1946 that was addressing a motion to suppress for a violation of knock and announce. So it wouldn't just be Benfield's wrong, it wouldn't just be cable's wrong, it would have to be that Johnson, the analysis there is wrong, and it would have to be that applying the exclusionary rule for statutory violations that Jackson did in 24 Hart and 25 are wrong also. And that's a lot of wrong from judges that were around at the time and would understand the legal landscape at the time. If there are no more questions, thank you for your time.
Thank you. Appreciate it.
If your honors have no further questions for me, I'm happy to waive my rebuttal time, but I'm also happy to ask any other questions.
Doesn't it? I mean, so it seems like this is, if you look at sort of the spectrum of kind of sort of judicially humble things to do, it seems like this is a baseline that has been in place for a long time, that has been there for the legislature to change if they want. For us to, can you understand, so what would be sort of the most reasonable thing for us to say is clearly wrong about the status quo? And so at least two possibilities would be the statutory interpretation, which really there isn't. Then there's the kind of what are judges supposed to do when a statute is silent as a remedy. I mean, if we believe that we have to justify doing something different from the status quo by saying that there is a, demonstrable problem with what came before us for this long period of time, what is the most reasonable thing for us to say about that?
Well, I think that you would say that those decisions are clearly erroneous and that they were addressing a statutory...
Could you speak up?
Yes, sorry, Your Honor. I think you would say that those decisions are clearly erroneous because they were addressing a statutory violation. And the mechanism of enforcement for a statutory violation is a question of statutory interpretation that is up to the legislature. And the legislature here has not provided for suppression as a remedy. And just to Your Honor's point on the question of the stare decisis question, there is tension in the court's case law on this about what to do when a statute is silent as to the remedy. You have cases saying that when the text of the statute does not expressly provide for exclusion, that the court should not read that into the statute. But then you have cable that seems to suggest, like, maybe if the statute is silent, courts are free to come up with their own statutory remedies. So I do think the lower courts here are left not knowing what to do, which line of cases to follow.
And is there, where would the, are we asking sort of what the legislature would have understood the lay of the land to be when this statute took effect?
I think that's right to the extent that that's relevant to the interpretation of the statutory text. So I think, I mean, if this...
So this case boils down to us, the statute is from what, 1920 something?
23, yes.
So we're supposed to go back to 1923 and figure out what would the legislature have, what did they do in the language of the statute, but then reading that in context of the background law, what would they have expected the remedy to be?
I don't know that the question is what would they have expected. I mean, the question is,
what would the law have been?
Correct.
What
yes.
What would an informed reader of the law have understood the new law of Florida to be in 1923?
That's right, Your Honor. Which is why I don't think
And so the reader would have known that there's this explicit now statutory constraint on what law enforcement can do, and there is no remedy for it, or what?
That the remedy for a statutory constraint would come from the legislature in the context of this.
No, but I mean, but the legislature hadn't done anything, so there's no remedy then.
That's right, Your Honor.
So that's what we would be saying.
But there is a remedy.
Yes. So
there is the remedy that's specifically addressed, at least with respect to knock and announce in the search warrant context.
Yes. So there was the criminal penalties were adopted in 1923 as well for the.
Because they were thinking. We know there that they were thinking about remedies.
That's right.
For a violation. It's a little different situation where they don't address the issue of remedies at all, where they're silent, which would be a different. That's not the case we've got, but in some other case that involving the arrest, you don't have this argument that they were focused on the issue of remedies, and this provision that was adopted at the same time, in the same law, they're focused on the subject of remedies, but they do not adopt the remedy of exclusion of evidence, correct?
That's correct, Your Honor. We would not necessarily have that same argument to a statute that was silent, although we do, as I noted, we don't think that is actually dispositive. We think, this court has cases like Lukehart where the statute was silent as a remedy, and the court said because the statute is silent as a remedy, it does not provide for suppression as a remedy, and therefore...
But do you agree that methodologically, if there is a statute that's silent, we go back to the time, and in this case, you're saying maybe it's not silent, the scheme is not silent, but then we would go back to the time and understand what sort of the body of law was at the time and what the legal effect of this new statute going into force would have been. And it's possible that the legal effect would include that this remedy would kick in, even if it's not written on the page.
I do agree with that, Your Honor. If there was a long history of suppressing evidence obtained in violation of the knock and announce rule at common law, we would have a much more difficult argument to make that the codification of the common law rule did not include that remedy. But
could I press you on reliance a little bit? Let's assume, for the sake of argument, that we're past clearly erroneous. Clearly we just decide that the statute provides for remedy. It isn't the exclusionary rule. Your opponent argues at page 32 of the answer that the state is wrong to suggest that the only reliance interest that matters is the one of the criminal defendant. You've articulated very well that, the person who's organizing his criminal affairs is not, a reliance interest that we care about. But maybe we care about the reliance interest of his spouse, who's ignorant of the criminal conduct and lying in bed next to him, who has a privacy interest in this home, the children, other residents in the home. Can you address your opponent's argument that the settled expectations of those persons who perhaps in the last 100 years have come to expect, as I don't know, perhaps it's, if we polled the world, they might expect that, the police are going to knock and announce before they execute a search warrant. What about their reliance interests? Are their reliance interests irrelevant to this court?
Sure. I don't know that I would say other reliance interests are irrelevant. I just don't know that is the type of reliance. When we talk about reliance, I think we mean detrimental reliance. So that somebody...
Well, think about it this way. What is the goal of knocking and announcing? Presumably to protect, life, right? And injury.
Damage to property, yes.
Right. So if I'm the son of the defendant, and I'm playing by the door, presumably, I have an interest in hearing, oh wait, there's a noise, let me back away from the door. That's what I want the state to address, is what about those expectations? Are they real? Are they phantasmagorical? Am I making this up? Or is that not part of the logic for the practice?
So I don't think that's part of the logic for the practice, because I think the question is whether people have taken some sort of action or they've structured their affairs around the court's decisions such that if the court were to then recede from it, they would be left in a worse position otherwise. So that's what I mean by some sort of detrimental reliance. I don't think this court, by reliance, has meant that people have just come to expect the rule and they like it. And I don't think that there's any argument here that anybody has engaged in any sort of detrimental reliance, whether it's the defendant or anybody else, that they've structured their affairs around the exclusionary rule applying here. If there are no further questions, I thank you for your time.
Thank you very much. We're adjourned.
All right.